I'll just get started. So I'm going to I'm going to have a 20-minute introduction, basically talk about the Indian judicial system from an outsider's perspective. So I'm going to talk about my work in Pakistan and how it shaped my understanding of the Indian judicial system, the pros and cons, and then Mr. Parekh can take it from there and give us a greater understanding. So when we talk about the Indian judicial system and Pakistan judicial system, so they arose from the same common law English system. I mean, we were also wonderfully colonized back in the day. And what happened was that the first thing that ended up making India different from Pakistan was that they made the constitution within 3 years of its inception. So you've had the same one constitution since 1950, and you've had a relative uniform train of thought being established since then. So in Pakistan, you've had 3 constitutions, 56, 62, 73, and with that you've had 3 different ideologies which have been promoted. So it's now more of a hybrid system. It's not so much a parliamentary republic. Even if it is that, then it's also an Islamic republic, and you have this infusion of laws which are kind of different from India, especially when it comes to criminal law. In some facets, it's very similar. The criminal procedure code, the civil procedure code. So in some aspects it's similar, but in some aspects it's deviated as well.
There are 2 of you can come here.
You want to? No, sure, we'll take the plate. Yeah. So, sorry, as I was saying, so one would think that once this hybrid system initiated in Pakistan, that it deviated from the course of a parliamentary republic, that they ended up being very different. But during my time in Pakistan, I found that that was not the case at all. I entered in Pakistan to basically intern with civil rights litigation lawyers, and what I saw was not only basically the use of the Indian legal jurisprudence, but also an embrace of it. So what do I mean by that? Basically, there were 2 really important cases that I worked on. One was called the Asghar Khan case. And in that case, what happened was that in the 1990 elections in Pakistan, the military and the executive, the president, they rigged the elections in favor of right-wing parties to dethrone Benazir Bhutto. So we went to the Supreme Court of Pakistan, our civil rights firm, and we basically said, look, you need to establish some parameters for what is legitimate and what is not. Military should not interfere in political affairs of the state. President should remain neutral. I mean, basic understandings. And what happened was that we cited towards Indian law. In India, the understanding of a president is that, it doesn't explicitly forbid them from participating in political affairs, but there's basically a general understanding that they should just be, standing by and should not participate so much. So we actually ended up citing towards Indian law. And in the judgment, which eventually came out in October 2012, it was fascinating. The Supreme Court not only the Pakistan Supreme Court, they not only entertained India's jurisprudence, but they really examined it. Now, it would be one thing if they were citing legislation, case law, or Supreme Court judgments, but they went really deep. So they went to the 1950 chairman of drafting committee of Indian Constitution notes. And that's a more sophisticated analysis of a constitution. And they basically said, look, the executive is supposed to be just neutral, and basically he should not participate in political affairs of the state. So in the judgment, it was really interesting. You had 10 to 15 pages, just straight up quotations from the drafting committee of India, Supreme Court, High Court India cases. And then after those 15 pages of quote, the Chief Justice just remarked, these arguments have merit and we should do as such. Emulate the Indian judicial system. Parliamentary republic is what we should emulate. So when the judgment was made, there was no real distinction. They didn't say, well, I don't know if we are a parliamentary republic, but basically they said, India is a parliamentary republic for all intents and purposes. We are the same, so, that's how we should adopt it. So that was a very pleasant surprise for me. And in another case, basically the same model, public interest litigation, we went to the Supreme Court and basically asked them to hear cases when it came to rape victims being forced to settle their cases out of court, in clear violation of the Criminal Procedure Code. The accused and the police would coerce a victim to resile from her statements. So, it was a facade. And India was facing the same problem in the 2000s and still is. So we basically cited towards an Delhi High Court judgment. It was called what was it called? Yeah, Delhi Commission for Women versus Delhi Police, where there was basically a laundry list issued by the Delhi High Court that, basically was very progressive and very simple at the same time. That, okay, when a woman ends up being raped, when she goes to the police station, she should be afforded a therapist, there should be a female judge, female medical examiner, her statement should be recorded in camera, away from the accused, yada, yada, yada. And when we went to the Supreme Court with this Delhi High Court case, in its judgment, it was very similar to the Asghar Khan case. They basically quoted that laundry list and at the end said, we have no reasons to believe why the state of Punjab should not enact these rules, and this case is disposed as such. So two really huge examples of public interest litigation where Pakistan was emulating and embracing the Indian model, and these were matters, really huge matters. I'm sure you can figure that out. What was surprising to me was that in any other discourse in Pakistan, social, cultural, political, the idea of Indian train of thought being in Pakistan or having a role to play is pretty much dismissed. Look at the education curriculum, look at our constitution. I mean, even in parliament, no one is going to cite towards some Indian social ethic and say that Pakistan needs it. The ideology is that, for all intents and purposes, we have to have an exclusive identity that is different from India. The military has promoted it heavily. So now you have this, and this was fascinating, and it was further explained, with my interaction with, so this was the Supreme Court level, right? So one could say, okay, it's the Supreme Court, it's like the elite application of law. But even in High Court and Session Courts, you saw Pakistani lawyers basically using Indian law to support their cases. So there's the Article 241 in the Indian Constitution about by-elections. You had Pakistani lawyers go to High Court judges in Pakistan and basically cite towards that Article 241 because Pakistan has no article on by-elections. And what the High Court judges did was they said, oh, this is fantastic. Even though we don't have a law on by-elections, we'll just use the Indian model. And they were very receptive towards that. So this was not just something exclusively reserved to the upper 9 judges of the Supreme Court. It was High Court as well, lower courts as well. So that was fantastic to see. And a lawyer friend of mine, he made some interesting observations. He said that when you go to a High Court or a Session Court in Pakistan, if you use Indian law to support your case, you immediately gather the attention of the judge. Because, first of all, Indian law, unlike Pakistan law, in Pakistan is hard to research. Pakistan law you can research because obviously there are more books available and you can research it online. Everyone is lazy nowadays with Google and Pakistan law site. With India, they don't have the online luxury. So someone has to manually open a book, go through cases to find precedent. So a judge immediately finds that very impressionable. And aside from that, basically, like I said, in the by-election model, they end up basically knowing that India's had a uniform train of thought since 1950. They appreciate the fact that India is more sophisticated in terms of application of law. It's just generally understood. It doesn't even need to be said explicitly. So that was very interesting to see. What I'm trying to get at here is that while there are some pros about it as well, there's some cons as well that are attached to it. So I was talking about public interest litigation, and that is intertwined with the idea of judicial activism. Because what is public interest litigation? You basically go to the Supreme Court and ask them to provide your remedy. You don't go to the lower courts. You don't go to the sessions courts and the high courts and then the Supreme Court. Supreme Court just entertains the case and says, the executive and legislation has failed you, so we're just going to entertain your case first-hand basis. So Pakistan embraced that model of judicial activism as well. But unlike India, it has had its pros and cons. India and judicial activism go back to the 70s. Some say that it was out of a guilty conscience that India became more judicially active. In 1976, with the emergency of the Indira Gandhi emergency, what happened was that a lot of people were illegally detained. And what the Supreme Court did in 1976 was that they basically refused to hear writs of habeas corpus filed by detainees, basically asking the Supreme Court to intervene. And that was the low point of Indian judiciary. So after that, there's a thesis that because of that and that reception that they got, they ended up being more activist after that. And I mean, there's some thesis that it was just an organic process, it had nothing to do with emergency. But Pakistan had the same model, because after the 2007 lawyers movement, they ended up basically being more activist in nature. But while as the Indian general public has embraced judicial activism, Pakistani jurisprudence and Pakistani public is more apprehensive of it, because while I cited towards these examples where it had a really good role, national security, rape victim protection, but you also had a political side to it. I mean, Chief Justice entertained cases. I remember one was the regulation of vulgarity on television. Basically, a journalist entered a petition and said, there's too much Katrina Kaif on TV, so we need to regulate that. And the Chief Justice said, yeah, I cannot watch Katrina Kaif with my family at home. So, there needs to be a moral compass asserted. And, so there was some dangers there. And I'm sure that the same case is with India. But with Pakistan, now that the Chief Justice has been replaced, there's definitely more caution that is being asserted. We are like, okay, judicial activism was good, but it needs to be exercised on a very limited basis. I mean, there are various forms of judicial activism as well. I mean, it doesn't just mean that court entertains every case, but you can have selective judicial activism, just constant judicial activism. So when hopefully from my commentary on Pakistan's use of Indian judicial system, you have somewhat of an idea on what some of the merits are. I mean, some of the good aspects of it in terms of public interest litigation and progressive laws. And then, there's cons as well. I mean, you have this backlog of cases because of public interest litigation, and this idea that the judiciary is going to save everyone from imminent doom, and the legislation and executive end up becoming exhausted and not being able to perform its functions. So as I move this discussion forward and ask some questions, I would just have a couple of questions that I would like to ask. One, what do you think that the Indian judicial system is a model worth emulating for developing countries like Pakistan? I mean, what are some of the pros and cons that you would associate with it? I mean, backlog of cases, activism. And yeah, the second question leads just into it. I mean, is judicial activism something, that India celebrates? Is it something that can be used for the greater good of democracy in India in the future? Yep.
I think we'll go to Mr. Parekh after this, and we can take questions jointly for both speakers.
If you like, you can sit down here.
You actually have to run
You have to go. All right. All right. Then you're at the right place. Friends, I'm very happy to be here. In fact, last time I was here in October 2013 when I spoke on public interest litigation, a boon to Indian public. Talking about India and Pakistan, in fact, the legal fraternity should come very close to each other, and that's what I, as President of Supreme Court Bar Association for 2 years, at the gap of 2 years in between, the delegation of Indian lawyers of about more than 75, 80 people, each time there was a conference, we went at the invitation of the Supreme Court of Pakistan, and likewise we invited, and twice the lawyers came. In fact, once from Pakistan, the group was much larger. It was 146 people came, and there were the good seminars in both the places we had. And Justice Chaudhary, the Chief Justice, he was the Chief Justice both the time we went of Pakistan, and second time we went, he invited all of us to Islamabad. There is an auditorium of Pakistan Supreme Court where there was a function organized by him, and he hosted a lunch for us. The Interior Minister was very active about that our going there, and he hosted a function for us in Islamabad. And I was just telling him that both countries are very unreasonable about visa. Here this is a city specific, so we all had only visa for Lahore, so how could we go to Islamabad? So Interior Minister ordered Mr. Parekh, President of Supreme Court Bar of India, and 97 others are allowed. So there was one-page visa for all of us. And then some of our friends were Sikh. They wanted to go to the birthplace of Guru Nanak. So again, you needed that visa. So one-page visa was given. And to see that nobody dishonored that one page, they put some security people with us. So, but anyway, it was very, very interesting thing. And these interactions are very, very useful. Ultimately, we are one country. We have become two countries very well, but the legal system is the same. Habits are the same. The approach is normally the same. Unfortunately, in fact, in Pakistan, when the army took over at various intervals, it makes a difference in the legal system, because then the army takes over, then there is no law. What the general says is the law. So that makes a lot of difference. But in Justice Chaudhary's time, in fact, he has done much bigger things than what the Indian Supreme Court has done in some of the cases. Now, talking about the strength of Indian judiciary is the subject. The first and foremost has to be a constitution. Of course, there are written constitution, there are unwritten constitution which are developed like British, but India has a nicely crafted constitution. Now, constitution can provide many good things, but ultimately how it's implemented, because in old USSR, the constitution gave all sorts of freedom to everyone, and including the state or provinces could even secede from the union. But if you even whispered about seceding, you'll be no more next day. That is how the USSR functions. So there is no point in having a very good constitution if it's not going to be implemented. Now, the one good thing about our constitution is that Article 14, which provides equality both ways, that you will be treated equally, and state will treat all of you equally, and you will not be discriminated by the state. And state has been interpreted to include not only central government and state governments, but the government corporations, public authorities. If the government companies, if 50% shares are of a government, they'll all be bound by this constitution mandate. Then Article 19, freedom of speech and expression, that has been very much guarded by the courts, and in fact there is no provision in constitution to give freedom to the media, the press, but they say since a citizen has a right of free speech and expression, he cannot exercise that right unless media is free. So that right is conferred on media. All this is expansion which were not contemplated by the original constitutional makers. And likewise Article 21, which says life, personal liberty, life and liberty. So what's the point of having a life if you are not educated? So right of primary education is read into life. You can't have animal life. So all sorts of expansion has been done by the judiciary, and that has been willy-nilly accepted by executive authorities. They are not very happy with the Supreme Court's expanding its powers and the powers of the citizens. But some time back I was in Hong Kong, and Chinese advisor for foreign investment talked to me about India and China. He said, when we earlier used to advise, we used to say you invest in China because there is corruption both in India and China. But once you pay the necessary money, then your work is done in China, nobody can stop it. And in India, the new minister also wants money, and the new bureaucrats also wants the money. He said now things have changed because of judiciary. They believe that in China, there is no independent judiciary at all. So if the same government which has promised you changes, then you have no place to go. Whereas in India, you can go to an independent judiciary who will listen to you. So this also affects a foreigner, that if I enter into a country, if I have independent judiciary. Now the Supreme Court does legislate, and they don't now make even secret about it. That they are, earlier, they used to legislate in a stealthy way, but not admitting. But now they admit. Now Visakha is a judgment where the women at the workplace are harassed by the male superiors. So if a male is a boss, and if the woman wants a promotion, wants a transfer, wants a good posting, etc. You must give, the lady should give sexual favor to the man. The man happens to be the boss. Now, no laws came to protect these women. Supreme Court came out with a big legislation that this is how you'll do, this will be done. Every institution which has more than so many number of people, there'll be a committee in which majority will be of women, and various things were made. And they say we are only making this legislation till Parliament makes a law. The Parliament had no time for 20 years to make a law, and therefore what Supreme Court said was the legislation. Now, criminals, whether criminals should enter politics, again no law on the subject. So Supreme Court made law. They came out with this suggestion that when in your nomination form, because the Election Commission has power that anyone who wants to contest election must write various things. So in that, Supreme Court said we are adding that you must say, have you ever been convicted of criminal offence? Are you any charge sheet pending against you? Any criminal case pending against you? All that must be added, and Supreme Court ordered them to do. And Supreme Court said various. That again was a legislation and said this is law till Parliament makes. On this day, all political parties combined. They said this is nonsense. What Supreme Court judgment, we disagree, and they all came out with a very quick legislation to nullify this. Supreme Court granted stay. He said that this will be unconstitutional, your law. Therefore, we stay, and our judgment will continue. So things like that, it keeps on happening, and when it happens on environmental matters, there are a large number of legislation made by the Supreme Court. Of course, our Constitution gives power to the Supreme Court and High Courts to strike down laws made either by Parliament or the legislatures, the state legislatures. The Supreme Court has given to itself one additional power that even if you, because what is if your law, an ordinary law, can be struck down only if it violates the Constitution. But supposing you amend the Constitution and say that such a law will be valid, then what will you do? So Supreme Court says that even that constitutional amendment we can strike down if it affects the basic structure of the Indian Constitution. And what is basic structures, we cannot tell you in advance, but equality certainly is, liberty certainly is, etc. So that Supreme Court today, the Parliament can't amend the Constitution to say that I nullify the Supreme Court judgments, unless of course there are certain things which earlier some judgments on the law of properties were changed by Parliament, but that's okay. Liberty is more important than property. Of course, property right restrictions are not that much objectionable. Now, we have a constitution where if any law made by Parliament or state legislature is put in the 9th schedule by the Parliament, is a schedule to the Constitution, then it will be immune from being struck down by the Supreme Court. Supreme Court says, of course, it says so, it is immune, therefore I cannot interfere, but if it violates basic structure, I can even strike down the laws which are having that constitutional mandate that you will not strike it down. So day in and day out, Supreme Court does control, and the corruption, I won't say there is no corruption in Supreme Court also, but it's much less perhaps than with the ministers and the bureaucrats, etc. So a common man today believes in India that, well, I don't know whether Supreme Court has power to do this or not. And I'm sure if you ask Dr. Ambedkar, who was the chairman of the Constitution Committee, who made the Constitution, wherever he is in his heaven perhaps, and ask him, did you make this Constitution as Supreme Court has interpreted? He would have said, no, I never imagined that this is what Constitution I am making. So it is the development from time to time which the Supreme Court has done has strengthened the Indian judiciary. Now, one thing which normally executive authority does is to pack the courts. You appoint the judges who listen to you, or judges who believe. In fact, in USA it happens. Your present Chief Justice was picked up from the appellate court and brought in the top. In Supreme Court, they laid down that it will go by seniority. Who will become the Chief Justice will be senior. In Pakistan, the bar fought for Justice Choudhury, when he was out and came back. So here again, Bar had fought the litigation. So now normally the court, all over the world is the government which appoints the judiciary. So while appointing, they can say in America they take into account what is his views on abortion, what is his view on capital sentence and things like that. But in India, it used to happen that because Congress party was ruling most of the time, so if the man is good to Congress party, he will be appointed, etc. It was not in a big way, but in a small way that was happening. And the Chief Justice had to succumb because otherwise they say, I'll not appoint, you have given me list of 10, unless you put my 2 names, I'll not sign. And so that type of arm twisting was going on. So Supreme Court by judgment has laid down that now the appointment, the Constitution says President shall appoint Supreme Court and High Court judges in consultation with the Chief Justice of India. The Supreme Court by interpretation has said that Chief Justice of India, which consists of Chief Justice and 4 senior most judges, shall appoint, and hell with you, Mr. President, in the sense that you have to just sign it, what we decide. That was judge's case number 2. Then judge's case number 3 was a presidential reference. Now, in fact, government has no power at all in the appointment. The entire power is taken over. For the High Court appointment, it comes from the High Court Collegium of Chief Justice and senior judges, and it is finalized by the Supreme Court Collegium. For the Supreme Court, it is started by Supreme Court Collegium and finished by them. And now this is a great power which judges have taken over on a wrong interpretation of the Constitution. As I said, the Constitution says that the President shall appoint the judges in consultation with Chief Justice of India. Now consultation, you can say, is not a mere formality, it's an effective consultation. Till then you are all right. But now it says we will not bother about President, really means aid and advice of cabinet. Then that power is taken away. So now judges don't have to bother. Other power with the judiciary in India is exercising it. Normally government chokes the judiciary by not giving them funds. Money is in the hands of budget. You'll have to have a budget and things like that. Now Supreme Court has got a public interest litigation of all India judges cases. So once a fortnight, the Chief Justice, whoever he is, he says that all right, we order government, you'll open 100 more courts in this place, you'll provide so much of money, you'll see that there is infrastructure provided to this institution. No budget of parliament, nothing. The Supreme Court judgment, if you don't do it, then you will be in contempt. So there are various powers which Indian Supreme Court has taken over, which can be said that is illegal, is wrong. How can they do what they are doing is really trespassing on the jurisdiction of legislature. And I won't say that critics will be wrong, critics will be right in saying, but things are moving like that, and it is in fact corruption is also controlled to quite some extent by this type of judgments. Now, as environmental things, the bureaucrats are by and large corrupt. So I'll give you one instance. Gomti River is in Uttar Pradesh. So one postcard was written by one Mr. Srivastava, a small man, nothing, to the Chief Justice, that Gomti River is completely polluted and the water is not potable at all. So Chief Justice Rangnath Misra was Chief Justice, and he told the court master, you call Mr. Parekh. So I was called in his court. Mr. Parekh, I appoint you as amicus curiae, and you please look at this postcard. And then I had to draft a writ petition. Now I have no personal knowledge, so when the court appoints you as amicus, whatever you write, it need not be affirmed. And whom to make parties? So to begin with, I said I'll make Union of India and State of Uttar Pradesh as parties. As the things went, I will write to some lawyers in that area, and sometimes I go and visited them. And I said that three main culprits were, one was all the municipalities, corporations, and they just throw untreated effluents of the whole town or city or village or whatever in the river. The second is the liquor manufacturers, distilleries. And third was the sugarcane manufacturers. And they all just do what they like. Of course, there is the laws are there, then there is a pollution control board of central and states. You bribe them, they'll come and certify that everything that you have done is complying with law. So I then made all those people as their parties, these municipalities. Union of India came and gave affidavit that since this river does not go outside one state, it is only in UP, I have no responsibility. It's the job of UP government. UP government said that how can I afford to have this type of treatment? And municipalities say we are all totally insolvent. We have no money even to pay salary to our staff. What do you expect us to do? How do we look after this? So then the Supreme Court started passing order, do this, constitute this committee. These people will say, Mr. Parekh has submitted a report to bring so many crores, so many 100 crores to be brought in. All by judicial order, nothing to do with any legislation. So much so that then a stage came when an order was passed that now I give 3 months time to all of you to comply with the norms, failing which you will stop your industries. And some of them complied, some of them who did not comply were stopped. Now one man who stopped was a distillery chef, Mohan Mekin Breweries, very influential politically also and financially. What he did, he told the UP minister that why don't you reduce your standard of pollution such that all that I am throwing will become within the standard. So the notification was issued, and then again I as amicus curiae came across this. I said, what nonsense is this? So I immediately filed a contempt petition. By that time Justice Misra had retired, Justice Samant was presiding. He said, yes, I said, yes, they said they are complying with law because law has changed now. So the notice was issued to the minister who authorized this, to the bureaucrats, and to the chairman of Mohan Mekin for contempt that come along. And then they all had to apologize and say that this man was penalized and the normal law came back. So there are a lot of things which the court does which is not within their domain, but it's working out well. And I think, should I stop and ask for time for questions? Or yeah, unless you people want me to say on any particular aspect, you can ask my questions so I can.
We can take questions for both Ali and Mr. Parekh.
Thank you so much. My question is for Mr. Parekh. I find the basic structure doctrine very fascinating, particularly as contemporary situations and dilemmas come up. I know one area in India in the last decade or so that's been complicated is the Forest Rights Act and scheduled tribes in India's forested areas. And so I wonder, sort of from a legal scholarly point of view, how does the difficulties of decreasing land availability for cultivation, how does the decreasing availability for land for both cultivation for individuals, but then also for corporate interests, etc., how does that bring a challenge to the basic structure because of all of these very large, often incommensurable interests between parties, particularly forests, I think.
I'll tell you, as far as forest, mining, that is all controlled by Supreme Court orders. Because in fact, Supreme Court has ordered that there will be no mining in entire Karnataka state. So the ministers were involved in illegal mining. And so they have been controlling forest. Now there would be no forest in India but for Supreme Court intervention. What have they done in forest? They have constituted a high power committee of their choice. There's honest bureaucrats sitting or retired. They are all put in that committee. So the man who has the power to sign, their powers are taken away. And anything they want to do, the matter comes up because there are 2 green benches, because 1 bench was not enough. 1 bench is of Chief Justice of India's bench. So there are 2 forest benches. They say, all right, you want to do this? Let this high power committee submit report. And they are very honest officers and they will always submit the right report. And 99.9% Supreme Court will reject the government report and accept this high power committee report. So this is how things are happening. But as far as land is concerned, it's a scarce commodity. Now you need land, agriculturists need the land, and the industrialists need the land. Now now under the pressure of Supreme Court, a new law has been made. It became law 2 months back. where they have said that you will give a good compensation. After all, if your agriculture is, land is really everything for him. Now, if you are taking away it for business purpose, etc., then you must pay much higher compensation, so that with that money he can do something. Plus, if an industry is taking over, then one family member from each household whose land you acquire will be given job. So all this is done by judge-made law by Supreme Court. So there are a lot of things which they have done. But it is not easy, because there will be many agriculturists who will rather die than to part with his land. They get attached to it. But then, by and large, if you compensate them well, etc., then it works. So there are some good industrialists and good chief ministers. They join together and have a meetings with the agriculturists. They all come along and they say, all right, this is the current market rate, and we'll give this much to you, and your one child will be given a job. And then by compromise, also this is happening in a big way in India. But you are right, it's not, I mean, all problems can't be solved because of the crunch of resources in countries like India or Pakistan. From where do you bring the resources? So but to the extent possible, things are being done.
Thanks, Phil. My question was more on the fast track courts. So I had two specific questions to this. One is, how is fast track courts different from any normal court that functions? And two, how do you decide what cases needs to go to a fast track court, and why do those specific cases get precedence over the rest?
You see, fast track courts are at the lowest level also, and district court level. I mean, district court and below, and they give a lot of emphasis on criminal matters. In criminal cases, if you keep the accused in jail, sometimes they are in jail for longer than the maximum punishment which will be awarded to them. And that also Supreme Court by PIL say that all that, now release them. What's the point? At the end of the day, you assume that he is guilty, and then the maximum punishment is 10 years. You kept him for 16 years in jail, and the case is still pending. So that is, and in civil cases also, but this again is also controlled by Supreme Court, by judicial wing, about fast courts. That you so and so state, now you have got only 100 fast court, make 300. And therefore, 300 means you don't have to pay only salary of these extra judges and the infrastructure and all that. But it's working. It is still not fast, because the litigation is so much, and people want to go to court. I won't say Indians are litigious, but they love to go to court, and then you will get some relief. But it takes a long time, and at times it's very, very disappointing for lawyers or for anyone who comes in touch with litigants. At the end of 40 years, one generation is dead, or sometimes second generation is dead, and the third generation gets the relief in Supreme Court at the end of the day. But this again is there are problems, but rather than having no solution, some solution is better than no solution.
But how does it function? Does it mean that they have to hear the case until the end on a day-to-day basis?
No, you see, I'll tell you, all the district courts are under the supervision of the high courts, under the constitution. And therefore they say that when it says chief minister, it really means chief justice of the high court. So the chief minister will not interfere with the judiciary. Lower judiciary appointment also, when the chief justice of high court gives the list, the high court, they will appoint them. Although they are at the state level, they are not high court or Supreme Court level. But how it works is, by and large, it works all right, because there is a supervision of this high courts over them. And at sometimes, if necessary, it comes to Supreme Court also for supervision.
So, as like common public, we see every now and then that judiciary goes in a different direction at times. In fact, very often due to lack of evidence. So, what role do you think judiciary can play with respect to strengthening the investigation and the police reforms, which can inform the judiciary better? Like the most popular example, Narendra Modi's clean chit due to lack of evidence when Justice Raghavan was probing the whole episode as SIT. A lot of people, like a lot of critics say that, I think day before yesterday there was a fresh PIL that asking for reconstitution of SIT, which was not entertained. So what do you think, like, how can that become better? Because a lot of public outcries about, including in Jessica Lal case, Narendra Modi's thing, like, how can lack of evidence?
You see, I tell you, by and large, both police of India and Pakistan, the only thing which police is taught when he joins is a danda, you know. Beat up the man, ask him to confess. So even if he has not committed the offense, he will say, yes, now how much beating can I take? So I have done it. He said, you done this. Now, you don't have manpower, you don't have trained manpower, and you are not taught into how to investigate. You see, and that proper investigation takes more time, money, and energy. And here, if someone comes on the front page of newspaper every day, then the police say that I must find out the accused. So, good or bad, at least I produce an accused. But it is a very, very difficult situation. I mean, for instance, in USA, your police constable is respected. When he says, don't do this, the person will not violate. Normally, getting 3 tickets is a big thing. In India, then you'll say, oh, don't you know, I know Farana, so and so. So you're, therefore, if your system is not controlled by efficient and honest people, then what you say will happen, and it's bound to happen. Then what happens, they will say, oh, this is Supreme Court will order monitoring, then things happen. Or not that our police officers are idiots, but the countries, I know, they are not idiots. They can do, but the burden of work on them, they have to look after all the VIPs and their security and safety. And in fact, the common man won't mind if your ministers are killed by somebody or the other. But they have to look after that service also. But there is no intention to really do the correct investigation, which will mean a lot of money, energy, and non-interference by the politicians. Because if the politicians interfere, they will tell the police, do this. If he does not listen, then he will be transferred. Which happens even in any ordinary case. I mean, recently this Vadera, the son-in-law of Sonia Gandhi, when Khemka was a madly honest bureaucrat, and he issued so-called notice. So he's thrown out to some training institute. So this, but it's not very easy to. What you say is an ideal situation to do a proper investigation, and therefore you are. But so much of corruption in police. I mean, one hears that if you want to be head of a police station in a particular area, which is lucrative, you have to bribe so much, and you have to continue to pay every month so much. Now that money you will pay to your commissioner of police or whatever, we will have to pay to the union home minister. Now if you have to pay all this money, how do you generate money? As a policeman, you can generate money by doing the wrong thing or not doing right thing. And there are only 2 ways you can generate money. So then if you want so much of money regularly from the policeman, how can you then insist that you do the right thing? You have to insist that you do the wrong thing so that money comes. It is again the reality of. So in few cases, judges will come over and take control and things like that, but it's not possible to do it.
I want to add to what you said, especially in the case of a criminal investigation, the basic tenets of doing the right thing, even to cordon off the affected area of the crime scene, is not being followed in most cases, and that contamination of the crime scene leads to botched cases, and every time the courts come very heavily on the investigating team, and the police they don't seem to learn from their mistakes. They do it over and over and over again. And it does not cost much, just to wear a couple of, rubber gloves or to just use some kind of a rope to cordon off. But because there are so many onlookers out there, they're definitely going to contaminate this.
But the police will like to run away when they see that some crime takes place, you know, so that's
I think that happens very regularly these days.
Good.
So my question is for you. So I've seen that how Pakistani judiciary has tried to meddle with some really proactive cases, which executive has invested a lot of political capital in. One of the case was about these power sector reforms, especially the removal of some subsidies in the power sector, and it was immediately dropped by the Chief Justice in his bench. So how would you say that whenever an executive is taking so much of political risk to come up with something which is good for the society at large, how can judiciary come in and then try to make these decisions void?
Right, that's a very valid point, and it is something that Pakistan is wrestling with actively. And I mean, this is a great example where, I mean, the thing is that the Supreme Court, because it has had the mandate of the people since 2007 because of the lawyers movement and how they dethroned Pervez Musharraf. So a lot of their actions, even if they are deemed to be unfounded by legal jurisprudence, they are validated by their perception. The danger is that the Supreme Court often interprets itself to represent the will of the people in Pakistan. They say it explicitly in constitutional judgments. So they also make statements saying that, oh, this democracy isn't even real democracy, something that you would hear in a drawing room discussion. But when they make claims like that, obviously it goes beyond activism, and it just becomes very dangerous because they have this elevated perception of themselves, which is facilitated by the public. And the executive has wrestled with this. I mean, there was the contempt of court doctrine that was used by the Supreme Court to basically get anyone who disagreed with them. First it was the executive for not following their orders, and then it ended up being lawyers who ended up writing articles about the judiciary. So, but the good thing is that because of the new Chief Justice, the judicial activism wave has kind of waned down. I mean, it exponentially rose, and it has not necessarily come to a drastic stop, but people went through the whole roller coaster, and people are just, it's the calm after the storm. So we're hoping that the new Chief Justice ends up being more respectful of executive authority. And it is something that honestly we will see through time whether it ends up happening. I don't know if that answers your question.
Yeah, sure. I just wanted to understand what is the source of this populist courts. Is it like enshrined in your constitution, or where does this...
Right. So Article 184.3 is basically grants the Supreme Court to entertain public interest petitions. What happens in a lot of instances is that people, because they see the court as an avenue for their political goals, they end up filing cases. So for